So in this video, I want to talk about how California is attempting to defy the Supreme Court's recent ruling in New York State Rifle and Pistol Association v. Bruin by passing a law which makes it next to impossible to concealed carry within the state. So let's talk about this. But real quick before we jump into this video, if you agree that the state of California needs to stop violating our Second Amendment rights, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So like I said in the intro, in this video, I want to talk about how California is now defying the Supreme Court's recent ruling in Bruin, which found that May issue licensing permits are unconstitutional. Now, if you're not aware, recently the Supreme Court issued a 6-3 decision in the New York State Rifle and Pistol Association v. Bruin decision, and that was authored by Justice Thomas. In the decision, Justice Thomas and the majority directly rejected the two-step approach and instead reaffirmed text as informed by history as the appropriate constitutional analysis when looking at the Second Amendment and various violations. The fact that the Supreme Court rejected the two-step approach bodes very bad for states like California, who have exclusively relied on that approach to uphold their Second Amendment violations. More directly, California was impacted by the decision because the court stated that California is among the 6 states which use a subjective proper cause standard when they issue permits. The court found states that use this type of standard are violating an individual's right to carry a firearm outside in public for self-defense. The Bruin decision therefore made the state of California's May issue licensing permits and that whole scheme invalid. Soon after the announcement of the decision, the Attorney General Rob Bonta released a letter to all law enforcement agencies stating that they could no longer use the good cause standard, the good cause requirement, to deny CCW applications. But it did also state that they could use the good moral character standard to determine whether or not someone should be granted a permit or not. Then the state of California and the legislature introduced a new bill, SB 918, which seeks to completely change the concealed carry laws in the state of California and essentially makes it next to impossible for someone to lawfully concealed carry within the state. And this bill, SB 918, was just passed out of committee and is heading to the state assembly for its second and third reading and ultimately towards a vote to pass it into law. So what is this bill going to change as far as CCW permits in California, and why should every gun owner in California be really concerned about this bill? Well, first, it removes the good cause language in the law as required by the Supreme Court in that Bruin decision. Now, really, that's all the state legislators should have done. They should have simply just stripped good cause language out of the current California law and left it like that. But they didn't. They went ahead and added much more language into this bill, and the whole goal of this bill is to make CCW permitting even more restrictive in the state of California than it was before. This bill first enhances the training requirements for a CCW permit. That's one of the first things it does. It changes the class time requirement for new CCW applications from 8 hours up to 16 hours and changes renewals from 4 to 8. So they are doubling the course time that you have to have and that they are mandating for someone to be able to get a permit to carry concealed or to renew their permit. They are also adding what type of instruction you must get. They're including a safe storage section, a law instruction section, mental health section, and then at the end of all that, you have to pass a written exam. But even before you get to take this insane course and the written exam and all that, your application may be denied by law enforcement agencies because the bill is pushing for a determination by these law enforcement agencies that people are of good moral character, or what they are calling now qualified persons. In the bill, they outline the process for being deemed a qualified person. You will have to do an in-person interview. You will need at least 3 character references, at least one of which may need to be a spouse or a partner if it applies to you. Also, the agency will review all publicly available information, including all of your social media posts. So not only will this bill aim to attack your Second Amendment rights, but it also touches on First Amendment issues and rights as well, because the state of California is attempting to chill speech, but also they are likely going to target applicants who do not fall in line with their own political agenda, that being the state of California's political agenda. So an agency or law enforcement agent who's reviewing your application may look at your social media posts and say, well, maybe he's a conservative and I don't like conservatives, so I'm going to deny him this application because I don't think he's a qualified person. But let's say everything goes your way and you're deemed a qualified person, you pass the course, you pay your fees, you're good to go, right? Well, no. Under this bill, the state is now adding in a super restrictive carry location requirement. Essentially, the state of California is doing something that Justice Thomas expressly stated was not okay in Bruin. The bill outlines that parks, various buildings, restaurants that serve alcohol, any government-owned property, and even more areas are off limits to carry. They also then throw in a catch-all concealed carry ban. The bill states that any other privately owned commercial establishment that is open to the public, unless the operator of the establishment clearly and conspicuously posts a sign at the entrance of the building or on the premises indicating that the license holders are permitted to carry firearms on the property. So essentially under this bill, almost everywhere, every business and private property will be off limits to carry unless the private business says that it's okay for you to conceal carry on the premise. That of course is a large task, and a lot of these businesses will just simply not do that. If the business does not have that sign that says that you can carry and you still carry on the premises, under this bill you will be charged potentially with a misdemeanor. Even though you had a permit, it was lawful for you to conceal carry, but under this bill, they just say almost everywhere is a sensitive place, and even though you have a permit, you still can't carry here. That is how insane this bill actually is. It is a plain and simple concealed carry ban within the state of California. This bill aims to make the process to get a permit even harder than it was before, and then also to make your permit almost useless within the state once you get it. So this bill does a lot more things than that. It also increases fees for applications. It allows psych evaluations for your application. But really, the main things that a lot of people are concerned about and focused on is the drastic changes to the whole CCW application process and the hyper restrictive new rules as far as where you could actually conceal carry once you get a permit. This bill flies in the face of what the Supreme Court just stated in the Bruin opinion. The state is simply removing one subjective good cause standard and inserting another subjective qualified person standard. Subjective standards are not permitted on the Supreme Court's recent decision in Bruin, but the state of California thinks that they can simply get away with this. Also, they are violating the Supreme Court's recent ruling in Bruin by trying to make every business in the entire state of California a sensitive place or gun-free zone unless otherwise stated. So the state's plan is to stall out applications for more training restrictions, a subjective qualified person standard, to stall things out as long as possible, make it as hard as possible, and then make it so that once you get your permit, it's almost useless because they said everywhere within the state of California is a sensitive place. Now, another concerning thing with this bill is that it has an urgency clause within it. The bill states that it will take effect immediately as an urgency statute upon signing by the governor. So this is something that is very concerning, and we as gun owners in California need to get together and oppose this bill because once this passes, it goes into effect immediately. Yes, it's unconstitutional. Yes, it's clearly a violation of the Supreme Court's recent ruling in Bruin. However, that will not stop the state of California from trying to pass this law. It is not stopping them whatsoever. They are trying to do anything they can to circumvent that recent Supreme Court ruling. No doubt if this passes, various organizations like CRPA, Gun Owners of California, FBC, and others will sue the state of California. But in the meantime, we will have to live under these more restrictive concealed carry laws and regimes. So please contact your representatives here in the state of California. Tell them that you oppose this bill and that they should oppose it as well and not vote in favor of it. And if they do vote in favor of this bill, that you will vote them out of office. Also, please spread the news about this bill. Spread it to everyone here in California and otherwise in other states as well. So as much exposure as possible gets pointed to this bill and what's currently going on, because we really need to stop this before it is actually signed into law. The status of this bill currently indicates that it's up for a second reading at the assembly floor next Monday on August 15th. So let's get the news out right now. Let's make a ton of noise and try to stop these tyrants from passing this bill, which clearly flies in the face of what the Supreme Court just ruled in Bruin. If you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys directly impact these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this is with Built by Armed Scholars, and this nation will be maintained by Armed Scholars.